Good morning, and thank you for attending the CLA webinar. I am delighted to welcome you to what I'm sure will be a very informative event on ownership and occupational rights against HS2. My name is John Greenshields, the CLA's Regional Surveyor for the Midlands, and I will be your chair for today's event. I would like to thank our partners Brabners and Rostons for supporting today's webinar on how best to prepare yourself for HS2. I would like to begin this webinar with a poll. This will give us some context for today's talk. As HS2 is progressing in separate phases, it would be useful for us to know what phase you're in. So we'll give that a minute to complete. You should be getting an answer any moment now to this poll. Okay, so that's quite interesting. The majority of these attendees are from phase 2B and a high proportion of professionals. I should have had my 10-year green book close to hand this morning then. Okay, so that poll was of use, as this event will work through a hypothetical case with some go-between between our two key speakers this morning, who will tell you how best to prepare for HS2. The first speaker we have this morning is Tony Rimmer, Director at Rostons, a firm of chartered surveyors based in Cheshire, who will then pass on to Sophie Stewart, Partner at Brabners Law, and Head of their Planning and Environmental team. I will then go on to talk about some practical points with dealing with HS2. That will leave us with approximately 15 minutes for questions, which will take us to 11 o'clock. Today's session will be recorded and will be available on the CLA website in due course. Please feel free to ask questions at any point during this webinar. If you pop your questions into the Q&A function at the base of your screen, please keep your questions short, although I imagine most of you will be more than competent with Zoom now, and we will be attempting to answer as many questions as possible at the end. So without further ado, it's my pleasure to pass you on to Tony Rimmer, Director at Rostons.
Thank you, John, and the team at the CLA for helping with the technical side, because that would certainly be far beyond me. We, as a firm of chartered surveyors and agricultural valuers, have been involved in phase 2A and phase 2B. I see most of you are involved with phase 2B, which means you've got approximately 12 months until the hybrid bill is submitted, or the back end of this year, to Parliament, and that will probably take a further 6 to 12 months through the process. So you've got time to sort out any of your occupational and ownership issues. Now, what we've encountered is many farms have a mixed bag of occupational arrangements and ownership, and this can make a huge difference to how you are eligible for compensation, how you're eligible for blight, how you're eligible for any of the compensation schemes that currently exist. If you're looking to protect your compensation when entry is actually taken, the key date is your structure and ownership, i.e. the legal interests on that date of entry. And that crystallizes your legal interests where you have your claim. So you're best placed to plan well in advance, and that is what we're aiming to do today. So this is a mythical farm. For those that are observant, it's just down the road from the office here. So it is definitely not affected by HS2. It's definitely not got a big housing scheme proposed. But to give you examples that will enable Sophie and I to interact and cover things, we've come up with this scenario, which is typical of many farms. you have effectively all the land is farmed by a farming partnership, father, son, daughter. So current generation and the future generation farming in partnership with no written agreement. We have an extensive dairy operation, very typical for those of us on the west on phase 2B, with a grazing network of tracks, and it's heavily reliant on the block to the far side of HS2, that red block. The different ownerships, we've got the red block, which is owned by Mr. Farmer and his daughter. We've got the yellow block that's owned by Mr. Farmer and his son. And then we've got the green block that is owned by Mr. and Mrs. Farmer, you know, the old original farm that was handed down from the previous generation, and then they've added different blocks to it. And then just to the east, we've got the housing development that has been a bit of a windfall development in the village there, as with many places recently. So that's the sort of background. And now Sophie, in a minute, is going to look at the different issues. So we need to look at the various compensation claims. You've got the land take, you've got the loss in value of the whole farm, the injurious affection, and the severance. And we've got the major grazing land less accessible, and is its value reduced? And then we've got betterment, with the potential for the housing to spread onto the adjoining land from HS2. Now, if there is betterment, it could be used to offset the compensation. If no, it's unlikely to affect the compensation. And what Sophie will start to tell us in due course is how these different ownerships of land and the occupation can have issues. Do we need written agreements? If so, should they be in writing, and why? I'd urge you all to consider the tax implications as well. We find it's very essential to get usually the accountants, the lawyers, ourselves sat down to try and sort everything out in one go if we can. And then we need to look at whether there's been recent compensation case law that has an impact on what's proposed. And that's why Sophie is going to have a look at Bishopgate and Annixter. So I think my next slide is Sophie. So I will hand over control to Sophie, and I will catch up in a bit.
Thanks, Tony. Yes, I am indeed going to touch on a couple of cases, the first being Bishopsgate, a problem particularly around phase 1 and the solution that's been introduced, and then also look at a more recent case of Annixter, which was last year. Sadly for us, the law giveth and the law taketh away in fairly short succession. Particularly looking around the implications and effects for compensation on minor tenancies about to expire. So minor tenancies are those for less than a year or which run from year to year, potentially holding over, and also potential implications where you don't have anything in writing. So I think the first point I should make is, Tony says, is it important to have your ownership and leasehold interests in writing? Absolutely, yes. It's really, really important, and particularly where you're going to be potentially affected by compulsory acquisition in the not too distant future. If you don't have things documented, you are into disputes and a void of information for quantifying your claim before you've gone anywhere. So the first case I'm going to look at today is Bishopsgate Space Management and London Underground Limited, a case from 2004. It caused a particular problem for phase 1 because HS2 saw it as an opportunity to effectively deny compensation to all those who were minor tenants. So as I said, tenants less than a year or year to year, or those on a longer term tenancy that had less than a year to run. The case concerned compensation quantified under Section 20 of the Compulsory Purchase Act 1965, albeit it did have wider application to all tenants other than those that had business tenancies with security of tenure under the 54 Landlord and Tenant Act. The court held in Bishopsgate that it was necessary to make an assumption, and it was an absolute assumption, that a landlord would terminate a tenant's interest at their first available opportunity following notice to treat. And that assumption was made regardless of the reality of the situation as to whether renewal was likely, as to whether a periodic tenancy would continue to run, or indeed, even with longer term tenancies that had break clauses, whether or not that break clause would be exercised. The reason Bishopsgate was so fundamental was it created a situation where an occupier with no formal interest in the land, so in this case, obviously Tony highlighted, we do have some parcels in our farm where we have people occupying, but without any written documentation in place, would actually, under Bishopsgate, be in a better situation in terms of compensation entitlement than a minor tenant, because when assessing compensation with no written agreements in place previously, the assumption that it would come to an end wouldn't be automatically implied. You would have to look at the reality of the situation. So HS2 seized on this for phase one, and they argued in a lot of situations that did arise because of the way quite often farming partnerships and land interests are formalised. There were shorter term occupation or leases that had come to an end and just hadn't been renewed because they were within family structures and they were quite happy holding over. And all of a sudden they found themselves not entitled to any compensation for loss of that leasehold interest. This was a problem out with HS2 as well for compensation all over the country. The government considered it to be so fundamental that they consulted on Bishopsgate as part of wider consultations back in 2016-17. And subsequent to that, amendments were made which took effect from the 22nd of September 2017. So everybody phase two onwards. They amended the statutory regime so that it is now explicit that when looking at compensation due for minor tenants and tenancies about to expire, the reality of the situation must be taken into account. Would that interest continue in a no scheme world for the purpose of assessing that compensation, and also to look at the terms upon which any renewal holding over would continue on. So on the face of it, we created a solution to Bishopgate to those affected. Brilliant, wonderful. However, it's still really, really important to identify the entity to which any tenancy is granted, because what the amendments to the statutory regime also made clear is that a trade or a business must be being carried out on that land for the amendments to apply. So we need to make sure that where there is anything in place, it is for the purpose of those particular tenants carrying out farming activities. It also leaves a bit of a grey space as yet untested as to what happens if it's land left lying fallow at the moment, and therefore whether the amended regime will apply or whether the old position under Bishopsgate would still apply to that piece of land purely because it's not classed as land tenanted out for the purpose of a business. So as far as Bishopsgate is concerned, realistically, we now have a solution. HS2 can't really rely on it as a reason to fail to pay compensation. But what did happen in 2020 was the case of Annixter. It came to court, will bring new opportunities, I think, fresh to the mind of HS2. And whilst Annixter didn't change any legal principles, it did clarify a couple of things which I think going forward, HS2 will now take into consideration, again, to look to minimise their bill. So Annexter was concerned with how you categorise a tenancy coming to an end, or what is a minor tenancy. In that case, there were 9 months left to run on a longer term tenancy. GVD was served, and the court was asked to consider, in that case, given the statutory amendments brought in 2017, whether actually the prospects of renewal of that long tenancy should be taken into account when determining whether it's a tenancy about to come to an end. And the court said, no, absolutely not. We appreciate it should be taken into account for compensation purposes, but when categorising the tenancy at the outset, we purely look at the factual situation. And that includes cases where you do actually have protected business tenancies as well, with security of tenure. You don't look at the renewal, you simply look at the contractual term left. So in that case, it was a long tenancy about to expire. And the upshot of that was actually the GVD was ineffective, because for tenancies about to expire, for minor tenancies, the only way HS2 can vest your land is using the notice to treat, notice of entry procedure. Why potentially could this be relevant to later phases? HS2 may very well take the tactic that they can vest superior interests under a GVD, so a head lease or the freehold interest. And then basically they can sit on their hands and wait for the minor tenancy or the tenancy that's about to expire simply to run out. What happens in that case? Well, unfortunately for the tenants, they are then not entitled to compensation under the compulsory purchase regime. At a minimum, if you did have a secure business tenancy or similar, you might get compensation under the Landlord and Tenant Act if there is an opposed renewal, but this is based on rateable value. For most agri holdings, this is going to be effectively zero. Given Bishopsgate has now largely gone for HS2, I wonder actually whether they are already plotting and planning to try and use Landlord and Tenant Act contractual arrangements just to get back, if you like, the benefit on their compensation bill that they've now lost. A further point that came out of Annexter is the difference of timing of serving of counter notices, which is really important. Again, in the case study for the farm, where we've got a strip of land that's going to be particularly affected by severance. If that is the case, when you receive your notice to treat or your GVD, you can serve a counter notice requiring HS2 to acquire the entirety of a holding or plot. And in Annexter, the point was largely moot because it was held that the GVD was ineffective to start with, because the NTT procedure should have been used, but the court considered it of public importance enough such that it should hand down a decision. And what it said, it looked at the language of the statutes. And in the case of a GVD, where you want to serve counter notice, you have 28 days from when the GVD comes to the attention of the person who is affected. However, in the case of notice to treat, you have 28 days from when the notice is served. And obviously that can make a huge difference if notices, and particularly at the moment, albeit hopefully it's coming to an end soon in COVID-19 world, where post is delayed, where businesses may not be open if you use registered addresses or PO boxes, you may not receive your notice in as timely a manner as you may hope. Which I think is a really, really important point to bear in mind. So what can you do? I would strongly say now and in advance of the next phases coming forward, take some time out to review and record your interests across your holding. Understand where you have longer tenancies about to expire, periodical tenancies holding over, licenses, and other interests, and schedule them and review that schedule regularly. Diarise key dates. When are things coming to an end? When do you start to need to look to renew things? Consider changing minor tenancies to longer term interests, particularly so that the GVD process is available, and HS2 potentially might be dissuaded from trying to cut your compensation entitlement by using GVD on superior interests and then allowing things to expire naturally. Consider drafting in those documents such that written interest can't easily be terminated by your landlord on notice, or without payments, or other more onerous conditions being met, such that if HS2 do decide to go down the contractual route to try and get rid of that minor interest, it's not so easy for them. So actually they may very well want to serve a notice to treat over it, obviously then engaging your right to compensation under the compensation code. And as I mentioned around timings for notices, make sure your contact details held at the land registry, held at Companies House, and also with HS2 themselves, if you once you know you're going to be affected, make sure they're up to date and update them if needed. Think about supplying email addresses, think about supplying 2 or 3 different addresses if you have them for service, to make sure documents come to you in a timely manner so that you don't lose opportunities. So that I think is me done for today. I'm going to hand back to Tony, who I think is going to give you some concluding remarks on this section and some more top tips from his surveying and quantification experience. Thank you.
Hello again, everybody. Thank you, Sophie. So as you can see from some of the recent cases, it is very clear that HS2, where they can, will look to use things that they can to reduce compensation. In the good old days, when I probably started off in this profession, you didn't find that everybody scrutinized legal interests as much. It was more done, well, that's how it works. Yes, we can see practically how it works. We'll agree the compensation. Whereas certainly there appears to be a starting point of, yes, we can see how it works, but actually legally, this is how you stand, and therefore you haven't got a claim. So if we just look at this example, if you remember, we had a big green area that was owned by Mr. and Mrs. Farmer, and within that they had the farmhouse, the farmsteading, the buildings, where all the investment had taken place to establish this modern dairy unit. Now, if we were looking at that as standalone from a valuation point of view, without the additional red and yellow land, it would be a very overcapitalized holding, and its value may be decreased. So when you're looking at assessing how you get that compensation, you might say, well, actually, we want to incorporate all the additional land. We might then look and say, well, the farming partnership is a legal interest, and it is going to be adversely affected by this scheme, because during construction, they're going to have to change things as to how they move cows. They're going to have to get extra forage in. They're going to have difficulty with going to the red and the yellow blocks. Now, if the partnership agreement isn't there and doesn't make clear how that land is being either held by the partners for the benefit of the partnership, or if there isn't a clear agreement on the structure, HS2 may say, well, those are separate legal interests. They're not part of the farming business. Therefore, for your compensation, we're just assessing the small green area. Yes, the red and the yellow areas will be assessed for compensation, but standing on their own. Now, obviously, it's very clear that the big red area to the west, left of HS2 is good grazing land. It's relatively close to the dairy unit. With a crossing, it's still accessible, but it's been devalued. The severance or possibly injurious affection, whichever way it may be. So you need to make sure you've got that partnership agreement right, so it's clear how the farming business is structured, how that farming business can get entitled to compensation. We then move on to look at the occupational agreements, because obviously this modernized, intense, invested in dairy unit without the red and the yellow land isn't as viable. So we would look to make sure that we've got tenancy agreements, but not short-term tenancy agreements, because we don't want to come unstuck, as Sophie has just described. So we would want long-term. The partnership can then claim for reorganization and loss of profits. This may allow the core business to reorganize and do investment, because it might have to change from that extensive dairy system to a house system for the 8 years during construction. That may necessitate investment in more cubicles, more slurry storage, more silage clamp capacity. Now, provided that is mitigating the claim, HS2 should consider it. So once again, it's making sure everything stacks up right with those occupational agreements. We then move on and we need to look at the land ownerships. Should we keep them as current? Should we actually all put the ownership into one structure that saves all this difference? You know, we've got the ability via tenancies to allow the business to farm. But then you'll recall we mentioned there was a housing development on the east. Now, that housing development on the east previously had a brook as a barrier, and the defendable line, arguably from the planners, could have been that brook. The defendable line in the future could be HS2. And actually, depending what happens, we could suddenly find that that land suddenly falls into the plan as a result of HS2. If it does, HS2 could argue betterment. And the increase in that betterment would offset, or increase in value of the betterment would offset your compensation claim. So you might not, in that scenario, want to incorporate all the land into one ownership. Now, that worked in that scenario, but this is a major health warning, because if you were looking to claim blight, you would not reorganize in the way I've just described. Because with blight, there is a statutory claims process, and it is very much, you must tick the boxes. So you must have more than 25% of the holding affected, and you can go to express purchase, which would avoid the need to market it. With normal blight, you need to market it. With the express purchase under HS2, provided you've got more than 25% of the holding affected, you don't need to market it. You must be owner occupied across all. Well, if we put tenancies in place, we're not owner occupied. If, on the other hand, you were a tenant and wanting to have your interest bought out, you must have more than 3 years unexpired. And if you're a landlord, as I say, it must be owner occupied, or you must have the ability for vacant possession. We have then had issues with what you and I would all talk about as long-term tenancies. A secure 86 Act tenancy is effectively, legally, a tenancy from year to year. So that doesn't meet the blight criteria. We've had scenarios where, due to family planning issues of tax, of protecting of the asset, there's long-term 86 Act tenancies in place on the land. That's fine for the tenant, But actually, if the owner is looking to sell to get blight, you can't do anything with it. And an FBT from year to year, once the term has expired, equally only gives you 1 year security. So that creates issues. So what starts off as a simple scenario, you suddenly learn has very different issues. So it really is essential that when you look, or when you are being affected, you take a step back and look at how your legal structures and interests stack up, because you don't want to get caught out. Now, the other thing is, we have given you a brief overview here, and you all need to remember that every circumstance is unique and different. We've tried to put a scenario that brings in so many different elements to give you an indication. You know, compensation is one area to look at, but equally you may have issues in reorganizing it with tax. One we've looked at recently to reorganize, the tax bill from capital gains tax alone was likely to be in the region of 500,000. You're not going to restructure it in that scenario. In every case, family dynamics are different. Structures are different. The objectives can vary depending on whether you wish to maintain that unit or whether you see it as an opportunity to sell up and move. So what I would say is you need to plan, because to fail to plan is to plan to fail. And that, in our view, is not an option. So review your position with your surveyor and valuer. Take advice of the accountant as to what you're proposing, how that can impact, and then plan. And for all of you on phase 2B, you have time to do this. And it could be the difference between having your ducks lined up when you go talking to HS2 and not having them lined up. So, as I say, Albert Einstein once said, in the middle of difficulty lies opportunity. What you've got to find is, where is the opportunity in this difficulty that is before us? So I will now hand over to John, who is going to come up with some top tips. And thank you very much, ladies and gents.
Thank you very much, Tony. Now that you've got your ducks in a row following Tony and Sophie's advice, and HS2 are ready to come onto your property, there are still several practical points that you need to address. As Tony's touched on, at the earliest possible point before the contractors come onto your land, get yourself your farm plan, lay it on your kitchen table, and absorb it before going out to do your day-to-day jobs, whether it's feeding or moving the cattle, or going out to fix a water supply to a trough. Think about how the HS2 route and the construction phase will impact the working of your business and any issues with different land ownership and tenancies. It may be the case that only certain issues are discovered once HS2 come onto the ground, and I'm thinking of something like an unknown culvert here. So it's early to start talking to HS2, get everything in order, so that if there are any issues, you can deal with them quickly. Which leads me on to a very important point, and that is have the contact details of everyone relevant to you. So that includes HS2's agent, the community liaison officer, who can be used to G up others, the agricultural consultant for HS2, and all of their contractors. Having these contact details are hugely important in getting any issue resolved early before it manifests itself, whether that is to do with compensation or day-to-day issues on the ground. But it's also to form good working relationships with these people, even the contractors, who at certain times can be very useful to deal with the small matters on the ground when HS2's agents may not be available for contact. So don't be shy with tea, coffee, and home baking. With all of these events, as it's been touched on during this, make sure you diarise events and dates. So get yourself a diary purely devoted to HS2. Because in HS2's eyes, if an event didn't occur or it doesn't have evidence, then it doesn't occur. So it's important so that you can claim compensation at the end of the day. So diarise what happened when, who was present, and who agreed to what. Because as some of you will be aware, HS2 are liable to change their mind. And this can extend to highly important items that will have a huge impact on a business. So this can be temporary greening projects and temporary land take. And if you aren't in the habit of carrying around a smartphone or camera, please get into that habit, because you can never take too many photos. And building on these points, I'd like to finish on rather an unsatisfactory point, which I've alluded to. And that is, in addition to all of the technical points discussed today, please accept that it's likely that HS2 will let you down in at least one way. But remember, you're not alone, especially those who are in phase 2B, and get ready for HS2 to stress test your life in various ways during the project. And it's best to be prepared to deal with HS2, and you need the strong foundations which Tony and Sophie have talked about during this webinar. And so that concludes this part of the webinar, and we now move on to the question and answer section. And so I will kick off with a few questions here, and they're both relating to Bishopsgate. So I think it'd probably be worth passing over to Sophie, and that is about assessing claims under Section 20. And can you please talk about how Bishopsgate applies, and can you also please cover the impact of Bishopsgate on business tenancies governed by the 1954 Act?
Yeah, sure. Thanks, John. So the two questions that have been asked sort of interrelate, both relate to the wider application of Bishopsgate. So assuming we're in a situation where land has vested prior to the end of September 2017, or certainly where a notice to treat has been served before that date, Bishopsgate itself did just look at compensation payable under Section 20, which is the section that governs payments of compensation for minor tenancies about to expire. So in the strictest sense, yes, you know, that is how the case was decided, and that is its primary focus. However, the court didn't limit its application to Section 20 only. It just discussed it in relation to Section 20 because that on the facts that was in front of them. However, there is, when you look at the language of the statute governing compensation payable for other types of leasehold interest, there's no reason that Bishopsgate could only be limited when you read the judgment to Section 20 itself. What happened in reality, and what certainly happened with HS2, is that where you have longer term tenancies with more than a year to run, clearly it doesn't apply to minor tenancies because they are constrained by compensation only being payable under Section 20 anyway. But longer term tenancies, arguably, yes, that assumption could apply, that in 4 years, 10 years, 20 years, that the tenancy would come to an end. But in practice, most acquiring authorities didn't take the point. Largely, I think, because it potentially could have ended up back in court, having an argument as to whether Bishopsgate did have the wider application or not. but also because obviously with the longer term reversion to run, and the longer that unexpired portion is, the less it's directly it's in direct correlation for how much compensation you would get, because clearly the longer interest you still have, compensation still has to be worked out based on that interest. So acquiring authorities generally, not just HS2, have never or did never take the point, although I think arguably, yes, Bishopsgate would apply to all tenancies, I think, apart from tenancies with security of tenure, which comes on to the second question. Does the assumption apply to a periodic 54 Act tenancy? So I'm assuming that's asking the question in a situation where you've got a tenancy with security of tenure that has come to an end, and for whatever reason, either a Section 25 or a Section 26 landlord or tenant renewal notice, request for renewal, hasn't been served. I think in those situations, anybody would be a fool to argue that the Bishopsgate principle applied. I don't think, even if you ended up back in court, that would have any legs whatsoever, because clearly security of tenure provisions are there to provide that business tenancies can go on for as long as either the business requires them or landlord has prescribed statutory grounds to bring it to an end. And obviously you would then have to prove the prescribed statutory grounds, and you would then still have compensation under the Landlord and Tenants Act, which I think would then just be flipped to a compensation assessment payable in a compulsory purchase scenario. However, what I should say is the legislative amendments that were made, so post 22nd of September 2017, it wasn't Section 20 itself which was amended. It was Section 47 of the Land Compensation Act 1973, which is a section that has general application to tenancies in their wider sense. So then for anybody that deals in this will know, the compensation code is here, there and everywhere. It's built up with case law and guidance and multiple statutes that have been amended over many, many years. So 47, Section 47 itself has wider application to tenancies, and it's that's been amended to say when dealing with tenancies, you now have to consider the reality on the ground, regardless, if you like, of the type of tenancy. Would it come to an end? Would the tenant want to go? Would the landlord want the tenant to go? Might they even offer them incentives to stay in certain situations? With farming businesses, I think some of that might be slightly irrelevant, because quite often they are held within family structures to protect longer term interest, but there may very well be situations where you have particular within a dairy farm context, for example, if there is a separate entity operating milk sales, for example, wholesale, separate to the actual farming and management of the cattle, you may end up in a much more commercial situation where there may be efficiencies for the more commercial business arm and the more agricultural focused farming operation, that there are synergies to keeping something there where a landlord may offer incentives, and that now would have to be taken into account. So I hope that answers the two questions. Obviously Bishopsgate is no longer relevant. I can see Tony putting his hand up. I think he's got something to add. Go on.
Well, I think, Soph, you just raised a very good point. Over the last 10 years, we've seen a lot of the larger dairy farms, as they've expanded, being encouraged by the accountants to set up farming companies. So on many, the dairy cows, all the milk production through the buildings is in one legal entity, and all the farming of the land is in another legal entity. Now that creates all sorts of problems from a compensation point of view. It's worked very well over the last 10 years from an accountancy and a tax perspective, but that really does start to test the minds when you're looking how the different claims will stack up. So I think particularly as there's a lot of people on phase 2B, it's fairly equal, the split between the West and the East. I appreciate in the East there isn't as many dairy, but those farming structures have changed a lot over recent years, and that is going to be an issue.
Well, thank you both for answering that question very thoroughly and running through the consequences. I thought I'd ask Tony, you mentioned statutory blight, providing the business structured in such a way that it doesn't meet the criteria. Is there any way that HS2 would be able to deal with any form of discretionary blight?
HS2 have the ability to deal with atypical applications. Now, the process for an atypical application is very stringent from an accountancy point of view. I can see Sophie nodding. She's sat on the other side of the fence in the dim and distant with a legal firm, an external firm acting for HS2. So she's she's poacher turned gamekeeper. She's seen it. So you can go through a very stringent process for an atypical. It is not straightforward. We have done them. It is very noticeable at the moment on phase 2B. We had meetings pre-Christmas where the HS2 representatives suggested where we had some scenarios like this, we went down atypical. But then post-Christmas, as you alluded to, John, they have a habit of getting out of bed the different side and changing their minds. They have now said they are unlikely to consider an atypical, which makes it very difficult with client management. We are convinced that it can only be done by way of an atypical, and we are having to go back to the drawing board and supply more evidence, more detail to get them to accept looking at atypical. But very much it does appear to be a starting point of no and keep the money in the treasury, which perhaps is understandable with the spend they're having elsewhere at the moment.
Thank you. And just across to Sophie, when we're talking about minor tenancies and making sure everything's in writing, what type of legal document would you recommend someone who says has a equestrian business on the farm and maybe some small storage lets as well? What type of agreement would you recommend people form for those two separate types of let business?
I mean, in a post Bishopsgate world, the form of the documentation now is probably less important. Pre Bishopsgate, I would have said you're better off with a license for both of those. Well, potentially, depending on the equestrian type, you may want to put in place a longer term tenancy. Say something under potentially 7 years, because anything over 7 years has to be registered at the land registry, which then just comes with its own administrative burden. So something in between, 13 months, 7 years. Post Bishopsgate, I think it, and this probably isn't a very helpful answer, but for both of those types of business, it really depends on how they're going to operate the relationship between the entity taking the interest and the superior interest above them, whether the reality on the ground is that they're there for short term or that they're there for longer. Obviously, I would probably say the equestrian business, give them a lease. It's the kind of business that comes with larger overheads in terms of ensuring your horse welfare and your facilities and everything else are there. You're probably going to have customers coming. So it does lend itself much more to a business tenancy. So if you have a lease in place, that would probably yield your best claim for compensation, subject to Tony not shaking his head vehemently, but that's certainly been my experience. In terms of a storage business, that's quite a difficult one, because they can take so many different shapes and forms. You know, it could be somebody that is moving house or is between premises and wants to keep some things in a disused barn for a couple of months, through to, you know, are you setting up a big yellow storage company type operation where you're renting out units for third parties to come and store their own things in lockup types. I would say the former in that case, probably a license. On a practical level, it just gives more flexibility for both parties, because bear in mind, okay, we are talking about this in the sense of HS2, but HS2 isn't occurring in a vacuum. And people are still operating their businesses and living their lives, or this is going on around them. So yeah, the former shorter term, but even say longer term, but you're just doing somebody more of a favor or a help out, probably a license type arrangement, something that is more formalized and operating as a commercial business. I would also always say go for a lease. Go on, Tony.
Well, it was once again a timely reminder that came into my mind when listening to us, the question on sorting out the lease arrangements or occupational arrangements. One mustn't forget planning, because whilst we might have whatever agreement in place, if we don't have planning for that use, HS2 would not take into account the value that comes from that use.
Yeah, it would be an unlawful use.
Correct.
And in the day-to-day world, you might also find yourself in hot water with the local planning authority as well. But that's a whole different topic.
I think you will find there is an awful lot of diversified businesses that probably don't have planning for everything that is going on the ground.
Yes. Yeah.
And once again, in there looking to find the answer no rather than yes when looking at compensation, they will look at planning and the planning status, and that can have a huge bearing.
Yeah, and I will add here actually, and funny enough, it builds on the last question as well, around purchases, deals to be done outside of HS2 standard statutory schemes. It's not directly related to blight, but I'm actually working with a company at the moment that's going to be or is affected in phase 2A, looking at an advanced purchase on a discretionary basis. And I was expecting to crawl through hoops, as Tony said before. I'm poacher turned gamekeeper. They've upped their game. The amount of hoops we're crawling through are quite phenomenal. But actually, out of the back of that going through, HS2 have crawled all over planning, and we have had a set of inquiries come through asking lots of questions around the lawful use in this case of a unit rather than an agricultural holding, and we are being taken to task on our planning due diligence. So they are incredibly thorough at trying to find every reason known to man, either not to not to make an advanced purchase, but you know, to minimize their costs, whether that's through denying things that would really make life easier for businesses, or in the assessment of compensation once they've come along and invested what they need.
Thank you. And Sophie, I think you make a very good point, is that HS2 doesn't exist in a vacuum, and rural businesses have 101 different competing agendas. And just on not existing in a vacuum, Tony, can you quickly talk about how people maybe in phase 2B might be affected by betterment? And is there a cutoff date from which HS2 can't come back and claim betterment?
Well, it's as the legal interest is crystallised, as I understand it, on the date of entry. So from a legal point of view, we'll either nod or shake her head. And, you know, betterment, it is that interest on the day when it's acquired, which is the market value that is being assessed. So I think that answers your question simply.
Yeah, it does. The only thing I think I'd clarify is where you've got a general vesting declaration, the date of entry is the date that the GVD takes effect, notwithstanding they may or may not come onto your land. With a notice to treat, it actually goes to, obviously they have to serve a notice of entry, and when they actually then come on your land, because a notice of entry serves to be the earliest date that they can rather than the date that they do. Which again then goes back to John's top tip: keep a diary, keep a contemporaneous diary about when they are there and what they are doing, to avoid arguments, and also so that if you do end up down the line at your limitation period for compensation claims, you don't suddenly fall foul because you're a couple of days late if you need to lodge a reference. It's really important with NTTs particularly.
Thank you. And that's really all we've got time for. So that wraps up this CLA webinar. I would like to thank you all for attending, and I would like to thank our two excellent speakers today who have given up their precious time to speak about this important subject: Tony Rimmer of Rostons Chartered Surveyors and Sophie Stewart of Brabners Law. I would like to leave you with my take-home message from today, which is prepare yourself for HS2 as soon as possible and take professional advice. View it as an investment. The next CLA webinar is on managing public access and livestock, which will be held on Monday, the 1st of March. Thank you, and I hope you will join us again soon. Please do not hesitate to get in contact with the CLA regional office for more information. Goodbye and thank you.